Welcome to U.S. Immigration TV. In this video, I will discuss some common mistakes and misunderstandings when it comes to the Child Status Protection Act, or what I'll call Cspa. Now, many people have a child who aged out or turned 21 and has to be left behind. The family is confused and arguing that the child was perhaps just a baby when the petition was filed. So how could it be that the child aged out when they were in diapers when the petition was filed? In this video, I will discuss and explain how the Cspa works so you can determine if your child benefits from the Cspa or aged out. Now, the Child Status Protection Act is extremely complex and confusing when it comes to calculating a child's age. Many people use the wrong dates or events when trying to figure out the mathematical formula, and they convince themselves that their child is eligible. So let's go through some of the components or calculations for the Child Status Protection Act. First is age of child. Now, except for minor children of U.S. citizens called immediate relatives, the age of the child when the petition is filed is not relevant to the Cspa calculations. It does not matter how old the child was when the petition was filed. For example, even if the child was a baby when the petition was filed, what is important for most children under the Child Status Protection Act is the age of the child when the priority date becomes current. That is the age that is used for purposes of calculating the child's age under the Cspa. Now, for minor children of U.S. citizens called immediate relatives, it's different. In that case, it's the age of the child when the petition is filed, and it has to be filed before the child's 21st birthday. There's no further mathematical computation. Children of U.S. citizens, file it before that kid's 21st birthday. But the other family and employment-based petitions have to use the age when the priority date becomes current. In fact, I've had cases where the petition was filed 1 week before the child's 21st birthday, and they wound up being qualified under the Cspa. And I've had other cases where the child may have been in diapers when the petition was filed, but were considered to have aged out. The next part of calculating a child's age under the Cspa is the processing time of the petition. Under the Cspa, the processing time of the petition may be subtracted from the child's age when the priority date becomes current. The processing time is calculated from the date the petition is filed until the date it is approved, even if the priority date becomes current many years in the future. For example, if a petition is filed and then approved 1 month later, the processing time on that petition of 1 month may be subtracted from the child's age when the priority date becomes current. Now, if it takes 20 years for the petition to become current, such as a sibling petition, F4, still all you can subtract from the child's age is that 1 month processing time many years ago. Now, many people mistakenly believe and consider the processing time to be from the date the petition is filed up until the priority date is current. That is wrong. The next requirement for the Child Status Protection Act is the 1 year sought to acquire requirement. Even if the child's age is calculated to be under 21, there is also an important second step that is required, which is for the child to pursue or apply for their visa or adjustment within 1 year of when the priority date becomes current. If they do not seek to acquire their visa within 1 year, they lose Cspa eligibility. Seeking to acquire a visa is usually accomplished by filing the DS-260, an affidavit of support listing the child, adjustment of status, or some other concrete step within 1 year of when the visa becomes available. Now, I've come across many heartbreaking situations or cases where the family overlooked this important second step, such as when the parent decided that only they will first go to the U.S. and later they'll bring their kids, as let's say, following to join. But they did not seek to acquire the visas for their children within 1 year of visa availability, of course, because they weren't planning on bringing the kids right now. But still, that 1 year deadline was missed or passed over, and the children would not qualify under the Cspa, even though their age was calculated to be under 21. In your case, even though you may have had your eldest child who was under 21, or even in diapers when the petition was filed, they could possibly be considered to have aged out. Perhaps it could still be possible that a child qualifies for benefits under the Cspa, depending on the mathematical computational formula for computing a child's age, as I've outlined above, which is based on the length of time the petition was pending between filing and approval, subtracting that age at the time the priority date becomes current, and they sought to acquire a visa within 1 year. However, if you have any questions or issues about your child's aging out or eligibility under the Cspa, I would suggest that you seek the advice of an attorney who can evaluate your child's situation and determine which of the family members or children are still eligible under the petition, and if the children can benefit from the Child Status Protection Act. I hope you have found this video helpful and informative. I will continue posting videos which I hope you will find helpful to you and your case, or to somebody you know, such as a family or friend. Therefore, make sure to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you again for watching and subscribing to U.S. Immigration TV.